This is one of a series of interviews being conducted of senior members of the Shreveport Bar for the purpose of recording and preserving some of the history, the color, and the flavor of the practice of law in Shreveport over past years. This is a special project of the Archives Committee of the Shreveport Bar Association during its ongoing celebration of the bicentennial year of the United States Constitution. Our special guest during this segment of the series is Mr. Marlin Risinger. Mr. Risinger, a native of Northwest Louisiana, is a well-known and highly respected member of the Shreveport Bar, who at the age of 73 has actively pursued the practice of law in Shreveport over a period of some 48 years. I'm Joe Milner, a Shreveport attorney, and just coincidentally a member of the same law firm as that of Mr. Risinger, that is Blanchard, Walker, O'Quinn, and Roberts. And the Archives Committee has given me the very pleasurable assignment of sort of visiting with Mr. Risinger, reminiscing, thinking back across the years in this special interview. Marlin, I want to express the appreciation of the Bar Association for your arranging to be here today and to share with us, as well as countless others who in the future will have occasion to view this recorded interview, something of the history and the color of the practice of law spanning these 48 years in which you've been a member of the Shreveport Bar. In the introduction, I refer to you as a native of Northwest Louisiana. Exactly where were you born, Marlin?
Well, Joe, first, I'd like to say I think I'm a premature senior, and I don't feel old enough to undertake this kind of thing, but I guess the years contradict me. I was born in Gandy, Louisiana, which is in Sabine Parish. It no longer exists. I think had two large sawmills there that my father had built for the Wyatt Lumber Company, and then he ran them, and I was born while they were living there. My parents were living there.
I see. Have you spent most of your lifetime in the Northwest Louisiana area?
Altogether.
And your parents, are they natives of this part of the country?
Well, my mother's a native of Jonesboro in Jackson Parish. My father's a native of South Arkansas, up near Junction City.
I see. And your father was essentially in the sawmill business through most of his lifetime?
Yes, until 1928, he was altogether a sawmiller.
I see.
And after that, he had a farm and did other things.
What inspired you, Marlin, to go to law school rather than following the trade or business pursuits of your father?
Well, when I went to LSU, I took 3 years through my junior year in just arts and sciences, and my senior year I went to law school as my senior year. You could do that then. And so at the end of my first year of law school, I got a bachelor's degree. I believe that was in 1937. And I came home with no idea what I would do, so my father just asked me to go with him down to the farm, which was some 15 miles out of Mansfield. And after about a month or so, I couldn't figure any way I was going to get off that farm. So I decided I'd go back to law school.
That was your motivation for beginning a legal career?
My sole motivation was to get off that farm.
Now, you've got a son, too, who's in the legal profession, Mac.
Yeah.
Where does he practice law?
He's in Washington, D.C. He's in a tax firm there.
I see.
I don't know what his motivation for going to law school was.
Okay. Obviously not to get off a farm, because you've never been never been a farmer.
He does.
But you were able to structure your undergraduate work and your graduate work in law school by combining your senior year in undergraduate work with your first year in law school, which
Right.
is an arrangement I don't think is no longer observed. And when did you finish LSU Law School?
1939.
And where was the law school physically located, Marlin, at the time you attended school there?
Well, the first 2 years it was in the north wing of those buildings there on either side, on the north and south side of the Campanile, and facing the parade ground.
Right.
And my senior year, we moved to the new law school, which was the Supreme Court building. It looked like Supreme Court, and it was then called Lesh Hall. They later took the plaque, took its name off of it.
For reasons that we need not go into here today.
And I finished law school there.
So yours was the first class then to occupy the then new law school building there on, I guess that's Highland Road.
That's right.
And the last class to attend law school in the old building adjacent to Campanile Tower.
That's right. That's right.
And I also understand, Marlin, that your class began the Louisiana Law Review.
Well, I would put it that the faculty, and especially Dean Hebert and Mr. McMahon and Dunstan Smith, they started the law review, and they used our class to do it with.
Was it started during your junior or your senior?
My senior year.
Uh-huh.
Senior year.
Were you on the law review staff?
Yes, I was the lowest ranking editor. I was the index editor, and there were no editors below me.
I see. Did you contribute any legal writings to the law review while you were there?
Yes, the one came out under my name. Dean Hebert worked with me on it, and when I read it now, I can read a lot more Hebert in it than I can read Risinger. But he assigned it to me and worked with me on it. It was on litigious rights, and it was an article in that first issue of the Law Review.
Approximately how many students were in your graduating class at LSU in 1939?
Joe, I'd estimate 25, around 25.
Were there any females in your class?
One.
Who was that?
Jean Craighead, and she was an excellent student, and she married Bill Shaw, who was in the class behind us, and lives and has practiced with Bill, who's a lawyer over at Houma. And I don't know whether she still practices or not, but she did for a number of years.
And I believe they have a son who practices law here in Shreveport.
Yeah, Marshall Shaw is here in Shreveport. He is one of their children, and he's a lawyer.
Besides yourself, were there any members of your senior class in law school who came to Shreveport to practice law?
Yes. Beside myself, Guy Wimberly came, and Hugh Stevens, whose father was a judge on the district court here, Judge Stevens, came.
Was he a sitting judge at the time?
Yes, he was sitting when we came. And Ferdinand Cascio came. Ferdinand was not a native of Shreveport, and I don't know whether his wife was a native or not, but he came and practiced here. He died young a number of years ago, Ferdinand did. And
he was an assistant state attorney, wasn't he, for a number of years?
yes,
Cascio,
yes, that's right. He worked out. He was an assistant attorney general. Yeah.
And I think maybe...
But engaged in a full-time practice also.
Right. And I think on a prior occasion when we've chatted about your class, you mentioned an Ed Robertson.
Yes, Ed Robertson, he was a native of Shreveport, and Ed came at the same time that I did, but Ed had lived here all his life. His father was a lawyer before him here.
I see. Was your class, Marlin, required to take a bar examination to be admitted to practice law? And where did you take the bar exam?
We took it in in the House of Representatives chamber in the state capitol.
And then when and where did you begin your practice of law in Shreveport after you had graduated from law school and successfully completed the bar exam?
Well, I think we graduated along in June, and I went back to Mansfield, and I suppose I took about 6 months to see if I could think up something else to do, but it looked like I might end up back on that farm, so I came on to Shreveport in 1st of 1940, arrived here sometime in January.
And where did you light when you got to the city from a standpoint of establishing an office?
Well, I didn't know any. I had no connection, didn't even know an attorney in Shreveport. And Charlie Hunter, who was several years older than I and had finished law school several years before I did, had come back to Mansfield to practice with Jack Colvin there. And he had a friend in Shreveport, Dixon Carroll, who was in a firm that was Judge Grimmett, Boatner, Simon, Carroll. And through Charlie Hunter, Dixon Carroll told me that I could use their library and that they were empty offices there in the Recoup Brewster building on the same floor. So I got a single office. You didn't go through a secretary or a receptionist to get to my office. When you opened the door, you had me.
I see.
And I used their library.
Do you remember what you paid in the way of rent for your single office when you started out?
I'm sure it must have been, it was probably about $20 a month.
Who did your stenographic work?
I did it. I had a typewriter and a table, and a little typewriter table, and I did it. Now, if I could use a secretary over in Dixon Carroll's office if I had something that I didn't get it to where it looked all right. She would redo it for me.
Well, you were sort of proceeding in the mold of Julius Long, who is reputed never to have had a secretary, brother Huey P. Long, and doing his own stenographic work. But
Yeah, very much the same.
But when push came to shove, you did have some help from your friends next door when you started out.
And I had help from them and more from Dixon and from Archie Simon particularly, who was the youngest lawyer in that firm. And he helped me in more than secretarial work. He helped me in research and in the form of pleadings that I was totally unfamiliar with, and I could go and find some in the courthouse, but I like to have someone else tell me look at them,
Sure.
Because they were very strange to me.
Do you recall the circumstances under which you earned your first legal fee?
Well, I didn't know Mr. Goldstein, who was in our firm, but
Alias
Elias
Goldstein.
Goldstein. But I did meet somewhere in my social activities. I met his daughter, Betty, and Betty was very interested in a project that involved the Caddo Parish Police Jury. The police jury was under some criticism for the way it was administering the parish affairs and parish funds. And her father, Mr. Goldstein, financed or paid for an audit of the Caddo Parish Police Jury's books, and they were going to have a kind of a hearing on it up at the City Hall auditorium. And Betty asked me to preside at the meeting, and I did, and it was kind of a adversarial type of proceeding. And Mr. Goldstein was on my side, of course, and I got to know Mr. Goldstein and Ms. Goldstein that way. And sometime after that, shortly after that, Mr. Goldstein asked me to come over to his office, and he gave me a first legal business, which was a garnishment to run on a bank at Mendon. And I finally figured out how to file it and got it filed, and didn't find anything in the bank account over in Mendon.
Came up with nada in your efforts to...
Came up with zero.
Well, how did you collect a fee? Did you send a fee after it became obvious that the matter was concluded because there was nothing to be levied upon through your garnishment?
Well, we had a minimum fee schedule, and there was a fee proposed, suggested fee for running a garnishment, but it didn't tell you what to do if you ran a garnishment and you didn't get anything. And I assumed that if you didn't get, you'd like going fishing. If you didn't get anything, you didn't get anything. So I didn't send a fee and any kind of a bill. And Mr. Goldstein once asked me about the bill, and I explained what I thought about it, and he said I was 100% wrong. So he suggested a fee, and so I made a fee of $50, which I thought I had struck it rich.
Sure. Marlin, where was the City Hall building located at the time you had the Citizens Committee to consider the stewardship, as it were, of the police jury from a standpoint of handling public funds?
Well, Joe, I pass a lot of parking lots in Shreveport and try to remember what was on that in earlier years, and sometimes I can't remember, but I feel sure that the City Hall at that time was on where a parking lot that's right next door to Can Electric, and right across the street from where that famous
the Strand Theater?
Well, no, it's a block up, block north of the Strand, where that newsstand is.
Gilmore's?
Gilmore's newsstand is. I think Gilmore's was kind of across the street from that building.
I gather then it was probably on Crockett Street, was
yes,
it not?
it was on, is the Strand on Crockett? No, it's on Milam.
Milam,
Yeah,
Milam, you're right.
Right.
Okay. Approximately how long, Marlin, did you practice alone there in the Rico Brewster building before you made an association with another lawyer or lawyers to pursue your practice?
I'm not sure, Joe, but I expect it was several months, perhaps 2, 3, 4. I don't remember.
And what were the circumstances under which you happened to affiliate with another lawyer or a group of lawyers?
When I came to Shreveport, Mr. Sidney Harrell wrote me a letter when I was still in law school, and he asked me when I was in Shreveport when I was next in Shreveport to come by to see him. He was interested in some aspect of litigious rights and saw the article, and undoubtedly didn't realize Dean Hebert's contribution to it, but so I did, I called on Mr. Harrell just to introduce myself to him after I'd been there a while, and I always thought that Mr. Harrell, who was a good friend of Pike Hall, the father of Judge Hall on the Court of Appeal, that he mentioned me to Mr. Hall, because Mr. Hall called me one day and asked me if I would come over, that he had something he'd like to get me to do. So I did that, and then Mr. Hall and Marion Smith both would assign work for me.
Were they both in the same firm?
Yeah,
together?
they were in the same. They were in the firm. They practiced on the name of Foster Hall and Smith. Their senior partner had been Jim Foster, who had been a district attorney and a trial lawyer in Shreveport.
And I believe you told me on one prior occasion that Holly Barrett was a former member of that firm.
He was. Holly Barrett was the sort of the archetype of a solo practitioner. And he had left, they were all good friends, but he had left to practice alone and was practicing alone. So I never practiced with Holly Barrett. I knew him well, but I never practiced with him.
Marlin, in 1940, of course, we were going into the war years. Did you go into the military?
Well, yes, I was taken into the military.
Taken into the military.
I was taken
drafted.
Yes. Before Pearl Harbor, I was drafted in August of 1941. And I was in the service for 50 months.
I see. Tell us a little bit about the nature and scope of your law practice with Mr. Hall's firm during the brief time you were affiliated with that firm before you went into the military service. What kind of work did you do?
Well, Mr. Hall did a lot of property work, and I did some. I could learn to fix deeds and mortgages, and also he had me introduced me to the examination of titles from abstract, and he showed me how to go to the courthouse and check the records, which at the time I went to law school, I didn't even know those conveyance records were over there. I'd read about the conveyance record. And Marion Smith did a lot of commercial work. He did considerable commercial work, including Hemingway Furniture Company. Frank Hemingway and Marion Smith were good friends. And I did a good bit of collection of furniture bills for Hemingway's, and that was all in city court. I don't recall from the time I came to Shreveport until I came back from the service that I handled any litigation in the district court. I was there with Marion, and I'd be there with Pike on occasion, but I never handled anything. But I handled totally independently the furniture collections up on city court.
I see. And developed some expertise in that area.
Yeah, got a judgment on a number of them.
You mentioned some title work that you had done. Do you remember the first time you discovered a defect or a flaw in a title that you had under examination?
Yes, I remember that distinctly. Mr. Hall had shown me how to chain the title, and I certainly, and I examined a number, and I tried to find something wrong with them, and I couldn't find anything that I could find was wrong. And one day, suddenly, almost as an intuition, suddenly I realized that there was a flaw in that title. And I went in and announced to Mr. Hall that I'd found a flaw in the title, and he didn't believe me at first, but I finally convinced him that it was a flaw. And Joe, I don't believe I mentioned that to you, but I don't believe I mentioned to you that to correct the flaw, we needed a correction deed was needed from Mr. S.J. Harmon, who was the stockbroker. They called it a bucket shop in those days, but you could buy stocks and securities through his office. It was up somewhere near the First National Bank, and I fixed a correction deed, and Mr. Hall told me to take it over and get Mr. Harmon to sign it, and I took it over, and Mr. Harmon wouldn't sign it. So I came back and told Mr. Hall that Mr. Harmon wouldn't sign it, and so he said, well, I'll go over and get him to sign it. And he came back about an hour later. His face was just white, and Mr. Harmon wouldn't sign it for him. So he called me in his office and told me that Mr. Harmon, he couldn't get it signed either. So I had been relieved of failing to get Mr. Harmon's signature was my first reaction. At least he had failed also, which was of some comfort. And he then, in my presence, called Mr. Harmon on the phone and told him, said, now, I've known you a long time, Mr. Harmon, but you're either going to sign that correction deed or I'm going to sue you for it, and you're going to have to defend it, and I'm going to get a judgment correcting it, and you're going to have to pay the cost. So evidently I couldn't hear Mr. Harmon, but Mr. Harmon, under that threat, he agreed. Said, well, bring it over here and I'll sign it. Well, I took it over. Mr. Harmon was a little gruff with me, but it was a distinct pleasure for me to go and get it signed.
I see. Marlin, some years later, weren't you involved in some way in a lawsuit that was brought by the late John Madison, who mounted an attack on the title to some land that you had already examined and approved title to?
Yeah. Yes.
Tell me something about that.
I examined the title. It was over. I examined it in Winsboro, and examined it from the records, and it had an unusual twist to it in that a purchaser had contracted to purchase the land with the seller reserving the minerals, but the contract was to be performed, I believe it was 2 years later. So then they completed the deed 2 years later. I may have been a year later. And I gave a passing consideration to the fact that someone might say that mineral reservation might start running when they entered into that contract to create that mineral servitude.
Rather than at the time of the execution of the deed.
Of the deed. But without doing any research, I decided, well, that can't be, because the property has not been sold and that servitude can't come into existence. I did it on my basis of my legal knowledge, or my intuition, I guess. So I approved the title, and the client dealt with the owner as if that mineral servitude had expired. But if that 2 years was not, that it had not expired, but if that 2 years, if it had run during that 2 years, it would have expired. My title opinion would be flawed. And we went along for, I don't know how long, some time, and suddenly I heard from John Madison about it, and he told me that he was going to file suit to attack that title because he thought that the prescription started running from the time that contract was made. So we litigated it. We didn't go to the Supreme Court with it. Yes, we did. We went to the Supreme Court with it all the way, and I won it. And I say I won it. My side won it, and.
But were you actively involved in the defense of the case? Because you were trying to maintain, obviously, too, your title at that.
Yes, I was.
It had passed muster on
I was
your
responsible for that title.
Sure.
So, and John Madison, Joe, as you know, was a first-class lawyer, and a first-class oil and gas lawyer, and I knew it at the time. So when he called me, I spent the first day or so kind of trying to get over the shock, and doubted my conclusion once he questioned it. I was not as assured as I had been, but I didn't have any alternative but to go ahead and gird up and fight.
Marlin, who were some of the judges sitting on the Caddo bench at that time? This is now before you went into the service, around 1940.
Well, Judge Mills, Ed Mills, and Judge Hugh Stevens' father, Judge Harry Stevens, they called him, and Judge Robert J. O'Neill, and Judge John R. Pleasant. Judge Pleasant, I think, had not been on the bench long. He had replaced Cecil Morgan, who had been elected district judge, and then was offered he left the bench to become an executive with then Standard Oil Company, now Exxon. So that was the court at that time.
You mentioned Judge Mills. Did you ever have occasion to be tardy in attending session in his court?
Well, like a number of young lawyers, I had one, and I never knew anyone that had more than one.
And what happened?
Well, when you arrived, Judge Mills was he was a big man, and he had a big head, and he had straight on. He looked like, and he had a large nose, and he had very fierce eyes and a very red face. And when he talked, he had facial mannerisms that his mouth would jerk, and it.
You're rather intimidating to a young lawyer.
Absolutely terrified, and he simply just peeled me. He told me of everything that was wrong about it. It was actually contempt of court to be late. And I went back to the office, and I guess I was asking for some kind of solace from Mr. Hall, but I didn't get it. He told me that. I said, well, you'll never be late to court again, but after Judge Mills has given you that lesson. So I've been late since, but I became less careful after the judges got to be considerably younger than I was, Joe. It seemed that
Sure.
I wasn't as concerned as I used to be.
Well, at the time you were relating this story to Mr. Pike Hall, didn't his secretary come in and announce that Mr. Hall himself was late getting to court?
Well,
on that occasion?
that would make it a better story, but I think that it was shortly thereafter that I was in his office, and Ms. Minnie French, his secretary, came in and said, Mr. Hall, what are you doing here? You're supposed to be in Judge Dawkins' court. Judge Dawkins was a federal judge, and this is the older Judge Dawkins. And he left without even getting his hat. I mean, he just was gone, and he came back a little bit later, some hours later, and told me that he wasn't going to tell me what Judge Dawkins said to him, but that he never was going to be late in Judge Dawkins' court again.
Well, Marlin, we'll agree during this interview to let the facts get in the way of an otherwise good story. Then that.
Well, not excessively.
Okay. What, Marlin, looking back during those early years, was there more or less formality in court than is observed by and large today? If you have an observation on that.
I think it depended on the judge. In Judge Mills' court, the older lawyers could they could be light and have be informal with Judge Mills. I never could be informal with Judge Mills, but the older lawyers, the younger lawyers didn't. We felt we would be taking liberties, but the older lawyers, even with those judges, they had a good time. It seemed to me they enjoyed themselves more in trying a case than lawyers have trying cases now. It seemed to be more of something that lawyers were doing that they really liked to do. They were having a good time doing it, and now it seems to me that it's much more businesslike, and as if time is very important to the court, to the lawyers, and everybody. And
Practice was more leisurely.
Yeah, more
pace at
leisurely
that time.
than it is now in court and every way.
Tell me something about Judge Ruth Hendricks' city court. What went on over there from the standpoint of order and decorum or lack thereof? And
well, we would get unruly over there, and even lawyers that were not in the case would be offering help to their side, and it would turn into kind of a turmoil every now and then. And Judge Hendricks, he was tolerant, and he enjoyed some of it, but when he would get enough of it, he would begin to bang on he kept a nice big gavel. He'd bang on his bench, and you learn that when he banged on the bench, he was really just still kind of participating in the melee. He just wanted to shout something himself. But he had a sign. They don't have them. I don't see them anymore. I guess they have them still. But it was an American flag, and when you turned it on, it lighted and the flag waved. I don't know how it did it. I never saw the inside of one. Well, when he had a switch that was by the side of his chair, kind of on the floor, and when he'd had enough of the disorder, he would reach down and turn on when the flag started waving, everybody sat down and shut up, because Judge Hendricks had all of it. He'd enjoyed all of it he wanted, and that was the end of that.
Marlin, do you recall the system or device that Judge George Hardy on the Second Circuit Court of Appeal used when he was tired of listening to an argument for a lawyer and ready for the lawyer to bring his argument to an end? Remember his taking the pencil and flipping it against the desk in front of him?
Yes, that's right. He gave you hand signals when you'd you'd said all that he
And you
cared
could
for.
hear the tapping of that
That's
pencil,
right.
and the more vigorous it got, the
That's
more
right.
impatient
It was
that signaled he'd become, I suppose.
it was like a metronome, except that it, instead of getting faster and faster, it just, yeah, I remember that.
Before you went into the service back during 1940, 41, were the attorneys, by and large, very busy with their practice?
Well,
I
I'm
mean,
sure.
was there lots of legal business to do, and were they by and large as busy as lawyers are today?
They didn't give me that impression. They were more leisurely about what they were doing. I believe, Joe, they were not keeping time records. They didn't work on time records, and they worked on matters that had deadlines. They worked on the deadlines on it, but they didn't keep time records. I didn't know anything about keeping time records until after 1963. I don't believe when I came
That's
to
after you
back
joined
to
that
Baltimore
firm.
that we kept time records, except just kind of keeping
Yeah.
our own record on it.
You told me previously, time to time over coffee, that lawyers back during that time would take time off to go sit in the courtroom to see a particular lawyer or lawyers perform, or to hear a particularly interesting case, or to socialize at motion hour, and we don't seem to have much of that anymore.
Even all of the young lawyers did it, and even the older lawyers would go to hear particular lawyers that they wanted to watch having a real adversary trial.
We'll be talking about some of these personalities
Yeah.
a little bit later. Marlin, when you went into the service, did anybody take your place at Mr. Hall and Marion Smith's law firm?
Yeah, Chug Hunter, who's now Judge Hunter down at Lake Charles, he arrived after I left. I knew him, but he was not there when I left. So I left, and Chug Hunter came to the firm. He was older than I and married.
Was he a native of this area?
No, he's from Alexandria. And then he went into the Navy sometime later, maybe, I don't know, a year, I don't know how long, but after I left. And when he left, then after he was gone, and I think before, it was after Chug had already gone, the same as it was for me, John Shuey came. And John then stayed until John had provision, and they didn't take John into the service. They wouldn't take John until later, and so finally he went into the service, and then they employed. They didn't replace with a younger lawyer then. They employed a lawyer to I believe it was Mr. Boland when I got back, Mr. Boland.
Judge Neil Boland's father.
Judge Neil Boland's father, right, who was a very good oil and gas and title lawyer. He practiced in Mansfield when I was a child.
I meant to ask you earlier, how much were you paid a salary by the firm?
Yes.
How much were you paid a month?
I was paid $75 a month for my first month, and when I went into service in August, and I was still being paid $75 a month.
So you didn't take a cut in pay when you went into the military?
No.
You said, I believe you were in the military about 50 months, or something in that range, and then...
Well, I did take a cut in pay because my pay in the military was $30 as a basic. Now, when I got to be a buck sergeant, we called them, then my pay was about equal to what I was making as a lawyer.
As a journeyman lawyer.
Right. And when I got to be a staff sergeant, I was making more.
Where did you spend most of your time in the military?
Well, Joe, I spent about I spent about 6 or 8 months at reception center, first at Camp Shelby and then down at Camp Beauregard, in the reception center where they were bringing men in. And then I went overseas to England, and I was in England for about 10 months, and then I came back to the United States to go to officer candidate school. I really came back to see my parents, my family, and the only way I could get back was to go to OCS. And then I went through OCS, and then I was sent back to England, and I was there about 2 or 3 weeks, and then we went across the channel and went into France just about the time of the breakout. If you recall, the breakout following the D-Day landing, and then they had a beachhead, and then they enlarged it, and then they had the breakout. And we, in my unit, ended up, instead of going on east toward into France, toward Germany, we turned and followed some German paratrooper division back toward Brest on the Brittany Peninsula. So we were delayed then with that, getting on then and getting back to the main action that was going on in the drive toward Germany.
So you spent most of your time in the European theater of operations.
And here in the United States.
Yeah.
I never went to the Pacific.
And I believe you were in the CIC during all of those years.
Well, after I left the reception, so.
Sure. And then, Marlin, when you came back, after you mustered out of the service, did you come back to the same law firm? Did you rejoin Mr. Pike, Marion Smith?
And I was the first to leave, and I was, the Army was very fair about it. I was first to leave the firm, and then I was the first one back.
Did Judge Hunter and John Shuey then come back and join the firm?
Yes,
subsequent to your coming back?
In that order, I believe. I think John was the last one to get back. Shortly after I got back, and very shortly, I think it was within 2 weeks of the time I got back. I had been to Winsboro to examine the title that was involved in the lawsuit about the prescription on the
with John Madison.
With John Madison, and had returned from that examination when I got back to the office, and they told me that Mr. Smith had taken Mr. Hall to the hospital, that he had seemed to be very sick, and Mr. Hall died that night of a stroke.
And then that left you and Marion Smith, and Chuck Hunter came back.
And John came back.
And then did you form a partnership of the four of you?
That's right.
By what firm name?
By Smith, Hunter, Risinger, and Shuey.
And how long did you stay with this firm?
Until well, let's see, John Shuey left the firm and went into individual practice, and Mr. Smith and Chug and I, and Chug became a United States judge, left Mr. Smith and I. And Mr. Smith, he wanted to reduce his, he was getting older, and he wanted to reduce his work. So my father-in-law, W.M. Phillips, Flip Phillips, had planned, I'd been married then some 4 or 5 years, thereabout, and to his daughter, and he had wanted me over with him. He'd never had a partner. He had shared offices with others, but he wanted me over there, and so I went over, but we shared offices, and Frank Kennedy was there sharing with Mr. Phillips, so it became, we practiced under the name of Smith, Risinger, Phillips, Risinger, and Kennedy.
You said that Chuck Hunter was appointed to the federal bench. I recall, Marlin, right after I was out of law school, started practicing law, and I was in court for the first time down in Lake Charles. I had an argument before Judge Hunter, and after I concluded the argument and, in essence, was dismissed and left the rear door of the courtroom, the judge called to me over the spectators were there and inquired whether Mr. Risinger was still representing all those rich widows in Shreveport. So what do you suppose he meant by that?
Well, he didn't mean true widows. I did a good bit of oil and gas work with independent oil and gas men. And I began to do work for them in their marital difficulties, and then I did work for the wives of some that I didn't represent in their marital difficulties. And I found that a divorce practice has got can have some unpleasant aspects at times of the personal conflicts that are involved. But when you're representing the wife and there's no dispute about the actual divorce, the matter becomes purely a business proposition of dividing the community. And dividing communities was a nice, pleasant legal work to do, especially if you represent the wife. If you represent the husband, you had kind of a disappointed opposing client.
So that was basically what Judge Hunter was adverting to with that parting comment.
I think that's right.
And I think we'd mentioned before, it was about 1963 that you joined our firm of Blanchard Walker, O'Quinn and Roberts upon your father-in-law's retirement.
Right.
Beyond the domestic relations work that you did, the title examination work that you did after you returned from the service, what other type of practice did you pursue? What sort of cases did you take on?
Well, I did pretty much what came to hand, Joe. I handled a suit, one of the earliest full-dress, full-scale suits I had involved in was with Marion Smith, and it involved a woman named Peggy Pull, who was kind of an adventuresome young woman down in New Orleans, had bought an old yacht seagoing yacht from Frank Hemingway, and she was told that the yacht was rotten. It was defective, and so she sued to rescind the sale, and I handled it, defending it, and it was one of the first early. I'm getting the time schedule here's kind of got out of, but it was one of my first cases.
So we all, have a very vivid and clear recollection of our first full-dressed lawsuit.
Especially if you won it.
Sure. And what did you win this one?
Yeah, I won it in part. I won it full out in the district court, and because the lady that was where I first encountered discovery, Joe. We had discovery in those days, but we were all just inclined to want to use the adversarial system of go into the courtroom, in the pit, and fight it out there, just come what may.
Keeping your case close to the vest.
That's right.
Before you went into combat.
You were willing to do without knowledge of the other side's case, as long as you didn't try to dig into yours. But in this case, New Orleans lawyer was handling it, and they were much more advanced, I think, than we, so he got us into discovery. Well, I had a better marine expert than he had, and in discovery, he determined, and I think correctly, that my expert was going to prevail over his expert, and that the boat would be found not to be rotten. And so he let his client take the yacht to a shipyard and strip it. And when they stripped it, they found it completely rotten. But when she did that, she couldn't continue with her suit to rescind the sale because she couldn't restore it to us in the condition that she had received it.
I see.
The boat had to be rebuilt after she did that. So that left her with a claim for damages, and they didn't prove the damages in the correct form. They wanted the cost of rebuilding the ship, and they didn't put in any testimony as to the difference between a sound old yacht and an unsound old yacht. So Judge Galloway, who had not remonstrated with them in the course of the trial that they were not proving their case properly, and I was afraid that he would. So he decided that they couldn't recover. But they appealed it to the Supreme Court, and the Supreme Court said that they thought reduction of $5,000 in the price of the yacht would do justice between the parties. So that was the outcome. I considered it a victory, although I don't know that Frank Hemingway did.
You tell me on a prior occasion that the plaintiff's lawyers took some pieces of the rotted yacht
Yeah.
to the Supreme Court itself, and
Yeah. When I went into the Supreme Court chamber, I was just horrified to see that he had brought all these rotten pieces of the keel and the wood that you could just take your hand and dig it out with your hand, and he had put it along the entire council, you know, those double tables that they had there.
Yes, sir.
And he had it all along there. So in the course of the argument, one of the justices asked him, he said, well, with all of that, pointing at all this rotten timber from the boat, he said, how did you lose? And this New Orleans lawyer, he said, that I don't know, Your Honor. I don't know how I lost with all that. Well, he actually lost because he did not try his case right.
But he did get some measure of relief from,
Yes,
from the Supreme Court.
He got $5,000.
Well, I have a note of two other cases I'll get you to briefly comment on, if you will, because I think that your case evolved in settling the law in a couple of areas. One is Davis versus Laster. What was that briefly about, and what did that settle?
Well, it was involved the payment to maintain an oil and gas lease. Joe, the well was a gas well, and it was shut in, and the lease provided for payment of shut-in royalties. But by clerical error, over a number of years, the lessee paid delay rentals, the amount of the delay rentals, and paid it as delay rentals instead of paying the shut-in royalty. The delay rentals that he paid was at least twice as much as the amount of the shut-in royalty.
But technically, he should have paid shut-in royalties.
Right. And it was attacked. The lease was attacked on that ground, and we successfully defended it.
And then there's a case of Adams versus Grigsby that I have cited, I know, in some briefs that I filed in some suits. And what was the point that was settled there, by and large?
Well, it's cited for the fact that water is a mineral, for one thing. But the case was, the dispute arose over the fact that an oil and gas lessee, who was my client, had a water flood operation there to force oil up from the ground by the use of water. And he drilled water wells. There was a wonderful aquifer there, I believe it. And he drilled a well, bought a little tract of land, and put a big high-powered pump and pulled water and used it to flush this oil down, pump it down the wells and lift the oil out. And it reduced the water level in the neighboring owner's farm. This was out near Greenwood, and there were a lot of homes out there on small tracts, and it began to interfere with their water supply, and they sued to stop him. And they weren't able to do it because the principle of law that as long as he would use what he was withdrawing, he had a right to withdraw as much as he wanted to use. In other cases, circumstances, you'd have water commissions that would regulate that and prevent it, but at that time, they didn't have any. And as far as I know, they don't have any now to protect freshwater withdrawals.
Well, in looking back over these 48 years when you've been a very busy and active and journeyman lawyer, have you observed or noted any changes in the style or method by which lawyers prepare their cases for trial? As, for example, you've touched on the matter of discovery. Obviously, we use more discovery now than we did back during those earlier days. In pleading, briefing of cases, use of jury trials and civil cases, and the time consumed in preparation of cases. Could you share some observations with us there with regard to any changes you see in case preparation?
Well, I think that lawyers today prepare better than lawyers did in that day, Joe. They're really, in general. Now there were lawyers that that prepared then endlessly, and I guess good trial lawyers always prepare the same way. They never complete preparing for litigation.
But we're talking in generality.
In generalities, that's right. Now, the lawyers then, it seemed to me that lawyers tried cases on it was sometimes called the jugular vein theory, that they picked out what the issue of the case that would decide the case. And they worked on that issue alone, and they did not divert their efforts into possible other approaches to the litigation.
Just to digress for a moment, Marlin, who are some of the lawyers who come to mind in that context?
Well, primarily both of the O'Quinns,
Mickey and Leon.
Mickey and Leon O'Quinn in our firm, they did not, they never varied, and regardless of the defense that the other side used, the other side, his opponent may use a defense totally separate from their own, they would just ignore the defense and incompetence in their own selection of the prime issue of the case. And they were very successful trial lawyers. Elmo Lee, it was before my time, but by reputation, he was of that same, he used that same principle.
Separating the wheat from the chaff, and just getting right to the lick law issues and focusing essentially on them.
Right. I know lawyers today, and I guess there were lawyers then that did it, who either attack or defend on all grounds all at the same time without distinction, saying that on the basis that the lawyer can't tell what the judge or what the court's going to find impressive, but those older lawyers, they seem to know. They worked more from a principle basis, Joe, that the principle was going to evolve, especially in oil and gas, which had developed not out of statutory provisions from the legislature, but just out of the court, and particularly those judges in a period there, Chief Justice Charles O'Neill primarily, that they devised the structure of the mineral law in Louisiana based upon some kind of remote references to some of the codal provisions. Sure. And it was a logical structure, and you could view it in the light that this principle will prevail. The more it departs from that, and the mineral code that has now been enacted, I don't think, if anything, it did not concentrate it, because it made a lot of statutory provisions, all of which are loosely jointed, while the old logical structure, you could depend on it. If you got a little far beyond you, when you extended it, you had to be confident it would extend.
You made an interesting observation a moment ago, Marlin, when you observed that by and large, lawyers seem to prepare their cases better today than they did maybe back during the earlier mid-40s. Why do you suppose that is?
Well, they have better equipment. When you had a secretary who was typing and making about 8 or 10 copies, and she had to make an erasure. You didn't want to go back to her too many times asking her to do it again, but that would just be in the form of the appearance of it. But I think that the law is so much more complex now that it just takes a lot more preparation. When I look at the Southern Reporter, Joe, at the place that it was when I started practicing, the number of the volume, and I look at the other one, the law has grown vastly greater. So it just takes a lot more work.
Or if you might comment over that same span of time, Marlin, on the economics of the practice of law, the standpoint of the way you set a fee for services rendered, and are lawyers more, by and large, more affluent today than they were? Or are they making a better living from the practice of law than they were back during those earlier years?
Well, the basis of fee setting was the lawyers. We had the minimum fee schedule, but that was just a proposed. It was a minimum fee schedule, and
that was set by whom? Was that the state or at the local
level? It's set by the Bar Association,
the local bar association.
That's been outlawed as being antitrust, I think.
Sure.
But
Marlin, was that enforced? Was there any enforcement of that?
No,
okay.
There wasn't any enforcement of it.
Excuse me, go ahead.
The lawyer largely valued his services. Mr. Sidney Harrell, I don't know this personally, but his firm, he and Mr. Kuzan, handled a matter for a Texas company that they chose to, and Texaco agreed to pay a certain amount per year for as long as there was a law firm of Harold and Kuzan. And whatever their services were worth that to the Texas company. And so the lawyers that did that type of work and could command that type of fee, they fixed the fee according to what they thought it was worth, and it was generally paid, and there were very few suits about disputes about fees. And their fees were not discussed in advance. I don't know, but I would expect that that fee that Mr. Harrell arranged with Texas company was done after the work was over.
Well, those would be exceptional cases, but your mainstream journeyman lawyer who had a diversity of work back in the early, middle 40s, how would he go about formulating a fee from a standpoint of time, responsibility assumed, the amount involved, ability to pay, and that sort of thing? Where would he place his emphases?
He would base it on the value of what was involved, base it on the outcome. He'd base it on his own idea of what his services were worth. I guess you could sum it up that he based it on what he thought was a fair fee, and the client probably thought was he was charging all that the traffic would bear. I guess it would fall somewhere in that. I guess it falls pretty well in that now, Joe, except that now it's done on time.
More of an emphasis on time.
Yeah.
Well, why do you suppose that is, Marlin?
I think the corporate clients now have they have house counsel and they have attorneys as house counsel whose job is to supervise and observe the fees that are charged. So they ask for hourly rates. They want rates for seniors, rates for juniors. They want work done by juniors as much as possible. They want work done by the legal assistants. Certain types of work can be done by those.
Do you think that gives them a sense of having more control over their legal expense by doing it by the hour and asking for periodic frequent billings?
And they have, hope they have a fair idea of what time would be involved in problems, but they can then look at they often want to have billings that show the time applied to various things so that they can judge it as to what the time is. I think that the average lawyer is better paid even relatively than the average lawyer was in the older times. Probably, maybe some of the, and I'm not speaking now of damage suit lawyers, they are a special category,
sure.
Plaintiffs damage suit lawyers. The older lawyers probably were better paid in those times relatively than today. They could command fees. And I think, say, in some of the cities in the securities work now in New York, that's still done where they're dealing with very huge values, but we don't have that much of that type of work locally.
I wonder if you'd comment on, over this span of time, on the delivery of legal services to the poor or the indigent, as for example in the criminal sector. Through the 40s and 50s, what arrangement or structure did we have in the courts or in the Bar Association for furnishing counsel to indigent defendants in criminal cases?
Well, we had then, as we still have now, except that it's been taken over by the
Indigent Defender Board.
By arrangements, a formal arrangement. So lawyers were just appointed by the court as officers of the court. They appointed to provide those services. And they then, and I think until it was structured into the Indigent Defender Services, on capital cases, they would appoint a lawyer with a certain amount, with certain required experience, and then appoint a younger lawyer to assist him. And lawyers did a lot of free legal work in civil matters for people that were not able to pay. I think the blacks were better served in that relationship with lawyers than perhaps the poorer income white people were.
Did we have any kind of, in Shreveport, any structured program during those early years for assistance in civil cases, like a legal aid office?
No.
Or is that something that came later?
That came later. That came later.
How often did your criminal appointments come up from the court?
Well, not nearly as often, despite the difference in the number of lawyers, not nearly as often as they got to coming up later. I think I served in my younger years, before I went in the service, I think I served in something around a year. I think I was appointed in a couple of minor cases, criminal cases. And then in later years, I got them, I had quite a number of them and got some serious cases. It took an awful lot of time.
Did you have a regular client, maybe an oil and gas client that you represented in a criminal case that you actually got paid for?
The only criminal case that I was ever employed to handle, I won. And I never won. I got some plea bargains that I thought were fairly good, but I never, the cases that I tried, that I was appointed on, I never won any. So
briefly, what happened in that case, Marlin?
I won't call his name, but he was an oil and gas operator up in the North Caddo field, and he was a very small man, but very agile and very tough. And a larger, much larger man with a huge stomach. was abusing him somewhat, according to what I was informed. And my client was sitting on the fender of a car. Cars had fenders in those days. And he was whittling with a little small whittling knife. And this man abused him and talked to him badly, and finally just approached him and finally just kind of reached out and was going to just grab him around his neck. And the eyewitness that I talked to told me that my client had said he just slid down off that fender and said, "Pass the knife across this man's belly." And he said the man's belly dropped down like a tailgate on a wagon. Joe, I don't know if you know how a tailgate on a wagon, like a tailgate on a pickup truck, and when it's not, doesn't have the chains or anything to hold it, when you free it, it just drops down. And the doctor testified in the trial that the knife blade was just long enough to cut through the muscles across the man's abdomen, but it didn't cut the peritoneum. And he said if it had, he'd have died there on the spot. But as it was, everything just came ballooning out, and this was his description of it.
But you won on a plea of self-defense,
Yeah,
I guess.
plea of self-defense.
Who was the judge in that
Judge
case?
Willie Woods, and I've always, a lot of my friends didn't think as highly of Judge Woods as I did as a judge, but I always admired him greatly for his decision on that.
Let's talk briefly about the Shreveport Bar Association, who's a sponsor of this special project. When I came to Shreveport in 1960, I believe you were president of the Shreveport Bar Association.
Before that, though, Joe.
Was it before that?
Yeah, I believe it was before that.
I was thinking it was in 1960 at or about that time.
Maybe, you may be right. You may be right.
I believe you were sucketed by Mr. Roberts in our firm, Robert Roberts Jr. in our firm.
I believe I succeeded Mr. Lockett.
Leonard Lockett.
Leonard Lockett, and Mr. Roberts succeeded me. Mr. Roberts was senior to me. That was a very embarrassing situation I was in.
I see. Marlin, would you comment, if you will, on the development and the growth of the Shreveport Bar Association as an entity across the years, from the standpoint of how it functioned, what services, if any, it offered, the extent to which it got involved in continuing legal education, for which it has a very high, priority now, and maybe something about the social aspects of the Bar Association?
Well, the bar didn't have any. The local Bar Association had no.
That's what I'm speaking to.
Yeah,
Is
it had no continuing legal education at all. When we went to the annual meeting of the State Bar Association, they would have section meetings,
Sure.
and you'd have things like that. But the local bar had nothing along that line. It had an annual meeting that was usually a barbecue, and it was stag, and no ladies were present, and it was in the evening. It would start in the late afternoon, and it would end up in those that wanted to participate in a dice game, a crap game, and it was the only place that I know of that you could shoot dice with a judge. I won't call his name, but he liked to shoot dice, and as far as I know, that's the only time he played dice during the whole year, but he would be one of the ones that would play the dice game to the very end.
Well, didn't you have any female members of the local Bar Association? Weren't they invited to these affairs?
Well, I think there was one lady here that there may have been more that were licensed to practice. Grace Williamson, I believe, was the only lady lawyer at that time that I recall. And no, she didn't come. It wasn't a function for the ladies. Now we had our monthly lunch meeting.
Where were they held?
They were held at the Washington Jury for the most part. And we had those were good meetings, and we had speakers that came, usually obtained more for entertainment than for educational purposes. But it was we all knew each other, Joe. The bar association relationship was different. You and I can go to a bar luncheon today and we look around and we won't recognize an awful lot of younger lawyers that are there.
Because that may be a factor of age, Marlin, to a certain extent.
That's right, that's right. And we'll look for faces that are not there because they hardly get there. So it was, when we met, we were all, as someone has said, all professional associations are a conspiracy against the laity.
Yeah.
And the Bar Association was kind of a brotherhood at that time. Not that we got along too good otherwise, but...
I think you were involved in some way in the racial integration of the Bar Association. Would you tell us when, at about what time that occurred, and your involvement in that?
Well, it was several years after I'd been president of the bar, local bar association, because I was no longer on the executive committee, and as you know, you stay on the executive committee
and then rotate off.
Rotate off. And I was no longer on the executive committee, and I believe, I don't remember who was president of the bar that year, but the executive committee, they were trying to put in a program, I believe it had to do with indigent defense, or some program, I'm not sure about the program, that would get federal funding. And, but they found that we were not qualified to get federal funding because we didn't have any minority members
in the association.
So I had, I had given up the principle of legal segregation, Joe, even when I was in law school. I for the first time, I didn't understand. I couldn't understand how it was there. And then I had an experience during the war that confirmed that intellectual in law school. It didn't change my views particularly there, but during the war I had an experience that kind of changed my emotional reaction to it. So I was opposed to the legislation, foolish legislation. If you recall, it was enacted by the state legislature in those years, trying to structure up continuing segregation. All of it by that time facing being declared unconstitutional. So my views were kind of on that, were kind of known, and a black lawyer had come to Shreveport that was, in my opinion, was qualified. He'd gone to Southern, but he knew what he was doing.
This was Jesse Stone.
This was Jesse Stone. And I got to know Jesse, and my friendship with him was known to some of them on the executive committee. So when they decided that they would integrate the bar in order to qualify for this grant, they thought that they would ask me to ask him to join. Well, I knew he had applied for membership and been denied by the membership committee on an early occasion. So I met with them and the executive committee and told them that I wanted assurance, that I didn't want to ask him to join. They wanted me to invite him to join and persuade him to join. And I told them that I wouldn't do it unless I was assured that he was not going to be rejected. So they assured me that he would not. So I made the invitation, delivered the invitation to Jesse, and he good-naturedly said, well, now, I don't want to be turned down again. And I said, well, that's why I'm coming, because I'm told that you will not be turned down. And he knew why they needed him before I talked to him. He told me that he did. But he said that, yes, he would join. He would apply. So he did. And the application for the membership didn't come to the executive committee, it came to the membership committee. And the membership committee turned him down again. And so they then called me to the meeting, joint meeting of the executive committee and the membership committee, or at least some of the membership committee. I guess maybe all of them, I don't know. And the membership committee was insisting that they were not going to admit him. And so I raised the question, well, what are you going to tell him? And one member of the membership committee said, well, we won't tell him anything. And I said, well, wait, somebody's going to tell him something. I'm going to tell him something. So if it's going to come to that, well, I think the Bar Association is going to embarrass itself. And so we had quite a... But then the president of the association told me after the meeting that said, it's all right, it'll be all right. And I asked him how he was going to handle it, and he said, well, if necessary, I'm going to discharge the membership committee and appoint a new committee. I don't think he had to do that, Joe. I think then the executive committee...
finally approved the application.
Yeah, the executive committee told the membership committee that either to approve... maybe some of the members of the membership committee resigned, but it was either they were going to accept him or they were going to be discharged from the committee, and the new committee would be appointed. It would. So that was the outcome of it, and he was accepted, and we got past that hurdle at least at that time.
I see. That's an interesting story. Marlin, over the years that you have practiced law, I'm sure that you could think of several lawyers that you would categorize as being particularly accomplished and outstanding lawyers from amongst the practicing bar here in Shreveport. What names come to mind in that context, and why would you select them as falling into that category?
Well, let me first name some lawyers who the reason for my putting them in that category is by reputation. I didn't, some of these lawyers, and I wrote down some names, Joe, because my memory about names has never been very good. But these were lawyers that I did not see in actual performance, but by reputation of lawyers that was older than I, who had through the years.
I understand.
I would think of them as kind of the preeminent lawyers of the period I'm speaking of, 1940, and then still largely, maybe some may have become older or died after the war, but I think within these general terms, Mr. Henry Walker, who was the founder of our firm, one of the founders, and Elias Goldstein of our firm of those days, and Sidney Harold, and his partner Sumter Cousin, and Elmo Lee, who not too long thereafter, I believe after the war was appointed to the United States Fifth Circuit Court of Appeals. And I would include in that group Mr. John Tucker, who was kind of our resident scholar. My impression was that Colonel Tucker, he was called Colonel Tucker, he didn't do a lot of actual practice, Joe, but he did an awful lot of scholarly work, and is entitled, I think, to the principal credit for the Louisiana Law Institute, because he was able to devote the time and had the inclination, the scholarship inclinations and abilities to get that thing going, and it's been an improvement in the Louisiana legal system, I think.
I noticed, Marlin, in looking, when I became aware of the fact that your class had inaugurated the Louisiana Law Review, and looking at that very first issue, that Colonel John Tucker had a very interesting article in there on the Louisiana Law Institute.
Yes, yes, he was working on it even in those days. Colonel Tucker would become, probably would happen when you went to law school. You learned about Colonel Tucker in law school because the law professors were all very aligned with him.
That's
in
right.
his work.
That's right.
And you developed an admiration for him out of their regard for him before you ever
Absolutely.
got to know him. I offended him once. He was over and he asked me into his office. He wanted to show me something, and he was showing me a paper that he had written about the Fideae Commissa under the Roman law, and he was back into all that. And I was just in not a mood for that day, and I said, Colonel Tucker, you really think you're going to find the true law back there in all those dusty, among all those dusty Romans? And he never was as cordial to me.
He took umbrage to that. You were fooling around where you shouldn't have been.
Yeah, I was meddling once I started
meddling,
talking about those old dusty Romans.
Yeah. Whom else do you have on your list, Marlon?
Well,
standing lawyers.
Mr. Leonard Hargrove was not. He didn't have a practice. He didn't practice openly at the time I came to Shreveport. He represented a man named Dick Norton, who had made a lot of money in the oil business, and he died relatively young. Died at the Democratic Convention some year or so before I got here. I guess it was in '38, and he had his name. He had an office in the old what's we call the Sklar building. It's been taken down now. And he had his name, but it was really the office of the Norton estate. And in later years, after he reopened, and he was the founder of the firm of Hargrove Guyton, Van Hook, and the present Hargrove Guyton firm. Then I had business with him and got to know him much better, but I knew him by reputation until that time. And he would be an eminent lawyer in anybody's.
I believe you told me he was a very careful and very meticulous lawyer, and you commented one time on some prior occasion about his examining a title to a piece of property and a requirement that he had made of a landman or somebody in that context. What was that?
Well, I didn't have personal experience with that, Joe, but this was a common story that was told of him to exemplify how meticulous he was. Mm-hmm. He examined a title that he himself was in the title, had owned an interest in it, owned it all. And somehow in purchasing it and in selling it, his marital status didn't appear properly. And he made a requirement of affidavits to prove his marital status, his own marital status.
And that's being careful.
And the story was that the landman told him that was to do the curative work on the opinion. Told him, said, Mr. Hargrove said, I never heard of it. Said, why are you asking for it? You know what it is, what your marital status was. He said, I know. But he said, some future examiner looking at the title is not going to know, and now I've approved the title, and he says Hargrove's a fool. He approves the title that doesn't show his own marital status. So he said, I want to get an affidavit, file a record, so we've got an affidavit showing what my marital status is. So Mr. Hargrove would go in any group. My own father-in-law, Mr. W.M. Phillips, who was a sole practitioner by his nature and personality, but he was I really got to know him as a lawyer in the years that I practiced with him when he was pretty old, but he was a fine lawyer. And I'd also want to include George Knapp, again on reputation, because I think Mr. Knapp had been with the Wilkerson, Lewis and Wilkerson firm, but had gone to United Gas and eventually ended up as president of Texas Eastern. And then I would also include, I think in that, I should include, although he was younger, would be, both of them were younger, would be John Madison and John Guyton, both who, and I knew them now from personal work with them.
Well, you had the litigation, of course, the title litigation with John Madison.
And I handled contracting and matters with John Guyton, and John Guyton was a splendid lawyer of mine. And there were many other lawyers but I'm just thinking of the ones that occurred. Of course, our own Mr. Leon and Mickey O'Quinn, Joe, they were among these. I had no experience with either one of them directly.
Sure.
When I was practicing myself.
Well, what about Mr. Scott Wilkinson?
Well, he was, I only knew him too by reputation. Yes, his name he would be in that list. Scott Wilkinson would certainly be in there.
What about Harry Booth?
Harry Booth he was the preeminent damage suit lawyer in Shreveport. He and Leonard Lockett together, and then Whitfield Jack joined them, and they were preeminent.
Harry Booth, by reputation, was one of the last big courtroom orators that
he was.
I recall.
He was not so much an orator, Joe. He was a showman,
actor,
right? And of course, Mr. Roberts in my early years was Mr. Robert Roberts he was with Arkla, one of the Arkla companies. But then when he came over to the firm, and Charlie Meyer, of course. I'm getting on down now into the Jim Van Hook. I'm getting down into the lawyers that are, anywhere from 5 to 10 years older than I am, that I have known and worked with and worked against. I've opposing Jim Van Hook or Charlie Meyer was almost as fun as being, I believe, more fun opposing them than being on the same side with them. I had some delightful experiences with both those two fellows.
Well, let's make the transition from these folks to, and that's not to say that they were not outstanding lawyers, to lawyers with interesting personalities who were amongst the more colorful members of the bar. Do you have some names jotted down in that category?
I don't think I need to. I've turned my page and I'm leaving out some of the names I want to include.
Go ahead and do that, and then we'll get to the other point.
You reminded me of Scott Wilkerson, but I would be very remiss if I didn't include Charles Egan in my high regard for lawyers, and Mr. Sidney Cook. I don't think I ever saw his brother Frank, but by reputation, Frank Cook was highly regarded. They tried cases as a team, Joe. Mr. Sidney Cook did all of the talking, and Mr. Frank Cook, I never saw this, but I was told, and he sat and was counseling with Sidney in the entire trial. They worked as a trial, as a team,
I see.
with Sidney doing the talking. And Pike Hall and Marion Smith, too, were very...
With whom you had a very close association.
Yeah, very close association. Really, on those two fellows, I wouldn't, on Mr. Hall, I felt with Mr. Hall that I wouldn't be kind of in a position to judge him. He was, I kind of hold him in a kind of a reverent sort of a memory. He was a fellow that was wonderful to me. So was Marion Smith. I don't mean to minimize Marion.
And brought you into his firm when you were just a young fledgling lawyer.
And on personalities, I suppose Mr. Frank Blanchard would be the lawyer of notable personality and annex of the bar of my memory, and as far as I know to this date. Leslie Barnett was a wonderful storyteller, colorful in everything that he did.
You told me one time something about something his wife said after his passing. Marlin, do you recall that?
It's personal, but it's so wonderful of him, about him, that those of us that knew him and loved him, after he died, his wife told Marion Smith, and Marion Smith told me that she said that Leslie didn't have a large place in this world to fill, but the niche that he had, he filled it completely.
That's quite a tribute.
And quite a tribute. I think it's as grand a tribute as you could say of anyone.
And who were some of the other more interesting personalities across these years?
Well, Holly Barrett was a personality that Barrett was a scholar, but he also had a wonderful and very broad sense of humor. He is attributed with evoking Mr. Julius Long's story that I believe one of the others that I believe Charlie Meyer.
Charlie Meyer, with regard to his stenographic work.
And if I recall, I heard Charlie give perform this same function, and I don't recall that he gave Holly Barrett credit for obtaining that, but Holly listed that out of Mr. Long in the course of litigation that he had with Mr. Long.
You have another story, I believe, about Holly Barrett with regard to a lawsuit he was involved in involving the Chalk Rock zone.
Yeah, he had a lawsuit that turned on a question of whether or not a well drilled up in the North Caddo Field had drilled to a zone that was called the Chalk Rock. And he produced a witness. Now, I didn't see this, Joe. This was earlier. He produced a witness that a black man who lived near the well and who was there around the well the whole time, who said that, yes, he knew that the well had been drilled at the Chalk Rock, testified. And Holly asked him, said, well, how do you know? He said, well, I know because my little boy, and he had brought the little boy to court. I'm sure Holly had arranged for him to bring the little boy. He said he was born just about the time, just after that well was completed. And everybody was so happy and thrilled that the well had hit the Chalk Rock that I named him Chalk Rock Johnson and said his name is Chalk Rock Johnson right now. And Holly then had a piece of chalk white chalk that he had arranged, and he proposed to the court that he would identify Chalk Rock Johnson by calling him Defendant's Exhibit Number 1.
Marking the little boy as an exhibit.
I think the judge, I think he cut Holly's joke, his maneuver off at that point, but Holly could tell that story himself with great glee.
Who were some of the other interesting personalities, Marlin, that crossed the mind?
Let me think a minute.
I know you've mentioned Otis Bullock from time to time, who's now deceased.
Mr. Bullock was not interested in the same. Mr. Bullock was not amusing. Mr. Bullock, he was an older man and had lost a leg, and he walked very carefully and methodically, and he questioned his witnesses very carefully and methodically. He did everything slowly and methodically. And you might think, as some of the lawyers, younger lawyers might think, that Mr. Bullock might be an easy mark, but the older lawyers who had tried cases with him would warn you to the contrary, that he was a formidable opponent and could be very, very disconcerting to his opponent in a trial just by the style of his handling. Joe, he could throw his opponent completely off balance by the timing.
I see.
And slowing the timing of the trial. And the judge might get very irritated with him, but he never changed his pace. No matter what happened, he proceeded at his pace.
His son Alfred is still practicing law in Shreveport. And you've mentioned Sam Love to me too. What about Mr. Love?
Well, Sam Love came from Mansfield, so that gave us an affinity that that a lot of people didn't share, perhaps. But Sam had studied law while he was working as a bill collector and collecting money that was tough to collect. And Sam was a real tough, he was a fighter, physically and temperamentally both. And it was a spectacle to see Sam sometimes try a case. You might just, he would crucify a witness that you just hurt for the witness at times. But he was fiercely partisan to his client and would be just unmerciful to his opposition.
Well, there was a city attorney in the Clyde Fant administration that you've mentioned in times past.
Norrie Marcantel.
Norrie Marcantel.
He was a favorite of mine. He was by disposition and temperament, he was a sole practitioner. He kept a very bare office and a very bare desk. And on several occasions I have met with Mr. Marcantel on some matter. He was a city attorney when it was not a full-time job. And he practiced law, and he was Clyde Fant's lawyer. And Mr. Marcantel had a great sense of humor, and I used to pick him up, see him wait for a bus and bring him to town, and got to know him real well that way. But when you would meet with Mr. Marcantel on a matter, he would have paper clips on his desk. He wanted to be busy with his hands. He was busy with, and he would talk to you very seriously, never right on the subject, but he was constantly then arranging these paper clips on his desk in various forms. Now, some lawyers said he was counting the paper clips, but he wasn't counting them. He would put them in stacks of 4, and then he would put them into another form, and it was just a way he had of a mannerism he had when he was concentrating on what he was talking about was to arrange the paper clips.
Marlin, we've talked about the active practitioners at the bar over these years. What about the members of the bench? Who were some of the outstanding, from your perspective, judges across the years of your practice?
Well, my favorite was, I had 2 favorites. I started with Judge Pleasant, who, as I say, I think Judge Pleasant left the bench not too long after it may have been several years after the war. But he was not on the bench all that long. But he was the opposite of Judge Mills. He was the young lawyer's support. And Judge Pleasant was one of the nicest men I've known.
Of course, he practiced for a number of years after he went off the bench.
Joined
still known as Judge Pleasant.
Yeah, and he was with Booth, Lockett, and Jack.
Sure.
And then my other favorite judge was Judge Galloway, who looked like such a wonderful judge. He was white-headed and very dignified, and yet could be very light and when he wanted to, but he was in complete control of, except he allowed Mr. Frank Blanchard more. Mr. Blanchard once announced that he was wanted to withdraw his counsel of record for a lady in a case that he was handling for, and Judge Galloway, I heard this person. Judge Galloway asked him, said, "Mr. Blanchard, have you advised your client?" And Mr. Blanchard would do his fingers this way when he was standing before the bench. He said, well, as a matter of fact, Your Honor, said, she advised me. And Judge Galloway would Frank Blanchard could monkey shine even before Judge Galloway. But Judge Galloway was my
Is this Sidney Galloway's father?
Sidney Galloway's father. He'd been district attorney, and then went on the bench.
How about Robert J. O'Neill?
Judge O'Neill was he was difficult a bit because you never could tell which way he was going to go. He would kind of intrude into your case at times as you were trying it and surprise you. I believe I told you of a matter of a succession that a will I was proving up before Judge
This was the blacksmith will?
Yeah.
Yes, if you'll relate that, please, Marlin.
A blacksmith named John O'Neill had prepared his own will, and he could write, but he wrote as an illiterate. In other words, he drew his letters, and he signed his name by drawing the letters of his name. And he wrote this will and signed it in his blacksmith shop with his friend who had a barber shop close by. And I had this friend on the witness stand after John's death. He left everything to his wife, Beulah. And she had asked me to handle his succession. And the witness testified that I showed him the will, and he said yes, he knew that was John O'Neill's will, that he had seen him write it and sign it. And he did it writing on the top of an overturned a keg, a barrel. And so I tendered the witness, and Judge O'Neill, the opposing counsel, asked him some questions, and he affirmed what he had told me to the opposing counsel, cross-examination. And Judge O'Neill would sit with his chair turned so that his back was to the witness stand, sit at right angles to the bench, and he turned and he faced the witness, who was a white-headed black man, and he said, you say this was Robert O'Neill that signed this will? And the man said, yes, sir. And Judge O'Neill said, well, how do I know which Robert O'Neill it is? There are many Robert O'Neills. He said, I'm a Robert O'Neill. And the old fellow, he turned and looked at the judge, and he looked him all up and down, from his head down to, and finally said, no, sir, Judge, says, you're not the one. Said, this was a colored man. And Judge O'Neill turned his chair back around, turned his back to the witness, and over his shoulder said to me, you may continue. But Judge O'Neill, he was a good judge. He was difficult as to how you could, you never did know exactly how to go about trying to handle your case before him, because he was a little unpredictable.
Right. Marlin, I have three more names that I had jotted down here when we had previously chatted. Judge Ben Dawkins Sr., who was on the federal bench for a number of years.
Yeah. And Judge Dawkins was a very powerful, fine judge by all reputation. I never did that much practice. He did, Chuck Hunter and I tried a case when we were partners together, claim on an life insurance policy. And Judge Dawkins took the case, we tried it before a jury, and Judge Dawkins took the case from the jury and decided against us. And when Chuck Hunter was appointed to and Chuck was indignant, as was I, and when he was appointed in later years to become a United States judge, I walked over with him to be sworn in. And as we walked along, I told him that, Chuck, there's one thing I want you to promise me. I want you to give a lot of thought before you ever take a case away from a jury to decide. And he promised to me faithfully that he would do it only in the direst circumstances. I've asked him about that later, and he must have taken a few away because he didn't recall the incident as well as I did.
I also have the name of Judge we call him Willie Woods. You've commented on him previously, and Judge George Hardy, who was chief judge for a number of years in the Second Circuit Court of Appeal. And I think it would be worthwhile, Marlin, if we could sort of put on the record a description of the procedure that I guess Judge Hardy instituted this, or at least it was in place during his quote-unquote administration, for an informal interview with your panel of judges in conjunction with an application for rehearing when you had lost the first round in the appeal. Would you describe that?
Yes, he had a procedure whereby when you applied for a rehearing on the decision of his court, the Court of Appeal, whether or not he was on the panel or not, that if there was any member of the entire court, not just the panel who tried it, who heard the appeal, then you would have a conference with the entire court. And I had one occasion where I had lost on the Court of Appeal decision and applied, and you had to ask for that conference.
Yep.
And I asked for the conference, and some judge, I don't know whether it was Judge Hardy or who it was, wanted to give me the hearing. So I got the hearing and went and was able to argue the case before the whole court informally with judges and them defending the position they had taken and me opposing the position, criticizing the position they had taken.
And not formally in the courtroom, but just around some tables.
That's right, where you were free, and made clear to you that you were free to assert without reservation what you considered. And you knew that at least one of them, and you could usually detect, or at least I could then detect, and I think it was Judge Hardy, that had wanted to give me the rehearing. And you had at least a possible ally on the court when you were. So it was, I don't know how much it changed the outcome of the case, Joe, but it sure did give a lawyer, and I think the client too, when you explained to him the opportunity you were given there, a better feeling about, if you lost, a better feeling about losing. You felt like you sure had a chance to present it.
Marlin, frankly, I want to thank the Archives Committee of the Bar Association for giving me this opportunity to visit with you, because I've really had a great time. This has really been enjoyable. And in behalf of that group, I want to thank you for being here today on this occasion and contributing to their special project in this special way. So thank you very much.
Well, Joe, I thank you, and I appreciate being invited. If we just had a cup of coffee, we could have had this discussion at the office at coffee time.
And we have.
And we have.
Thank you, Marlin, very much.